Hi to another edition of the Arsboni Travel Diaries. This time I want to report from a keynote that I had the privilege to give today earlier in the morning. It's during the Young Digital Law Conference 2023. That's a conference format organized primarily by non-permanent staff in academia all over from Europe. They meet, as far as I can tell, once a year. This time they meet in Vienna, which is the reason why quite some people from my department were in the organizational committee and are quite intensely involved in this. And this is also the reason why all four keynotes that are given during the 3 days of the of the conference are given by staff of the University of Vienna. If you happen to be in Vienna, or if you happen to have time on the 6th and 7th of July to visit this either in person or online, this is still possible. You are very kindly and warmly invited. I was there today, as I say, and as I said, and it's worth going there. It's really a brilliant group of people organizing this, and it's also a brilliant group of people listening and participating in this. My role, as I said, was to open this. The event was streamed but not recorded, which is the reason why I would suggest that I will briefly give you some kind of an impression about what I did there. It will not be exactly the presentation, obviously, but it will be a little bit of a summary or a wrap up a little bit faster than the original. I had 45 minutes of time. The question I asked myself was, what is young in young digital law? So obviously already from the title, it's quite clear that I wanted to provoke a little bit the audience, of which I thought and I still think that it's mainly young academics, young lawyers having the perspective to enter an academic career in law, in particular in digital law. And I wanted to share with them some of my experiences and some of my perceptions on how they how they do and how they behave and what their challenges might be. And that was also probably the reason why I already started with a warning, which was that my motto for this presentation would be a song from the German punk band Tonsteine Scherben, which in 1970, that's a date that already plays a role in this presentation, which in 1970 presented a song called Macht kaputt, was euch kaputt macht. So in English, something like destroy what is destroying you. And I said that this is, in a way, the call or the provocation that I wanted to use as a motto. So as I said, I wanted to wake them up. I was there quite early in the morning. And I started by showing them a computer, as a computer looked like in 1968, my year of birth. This is an iconic picture that I use in quite some of my presentations. I like it a lot for many reasons, one of them being that the only woman in the room is not really interested in what's happening. She's visible somewhere in the right. You see it over here now with the mouse. This is the only female here. There is a phone in the left corner over here. There is this melancholically looking into the future man who is supervised or controlled by this guy over there in the back. And the only person really doing the work is this man in the white shirt working on this huge machine. And this is, as I said, some way the starting point of my presentation from a historical point of view. And something like this is the ending point as it stands at the moment. These are the figures from ChatGPT from 2022, 2023, showing that it took ChatGPT only 5 days to achieve the first million of users, and that ChatGPT did significantly better here than any other of the big players here. So what you see here is that it took Netflix, for example, I don't know, something like 1,300 days to become large enough to have more than 1 million users. Spotify was much faster, Instagram was much faster, but nobody was just closely as fast as ChatGPT was with just 5 days. And since then, everyone working in this knows this. Since then, ChatGPT has shown tremendous growth rates, clearly over exponential growth rates, something like plus 100x% growth per month, which is a tsunami, an explosion that is happening here, that leads some people in the media to the assumption that this is some kind of another iPhone moment, so a life-changing moment, something which really changes how you perceive the internet, how you perceive your personal connection to the internet. And this life-changing moment, this iPhone moment, then is further described in this article that I was citing here, in the sense that ChatGPT, like technology, is pushing AI forward and is leading into some kind of tremendous change for reasons. First, it's, as this article says, it's democratizing data by making it more available. It's being adopted by a large number of people. It spurred technological development at warp speed, and it has numerous use cases. And my question then, or my provocation, was then that this assumption here that something like ChatGPT is democratizing data by making it more available is fundamentally wrong. In particular, fundamentally wrong in Europe, because Europe, as I then showed in quite some detail, is lagging behind. We are somewhere squeezed in the US-driven hardware industry on the one hand, and the Chinese/Asian-driven hardware industry from China, Asia on the one hand, and software industry from the US on the other hand. You can see this in reports like this one from ENISA from 2019. You can further see this in all kinds of the graphs indicating what's going on the internet in 2018 or in 2021, when TikTok appeared and TikTok really started to fly as a phenomenon among the youth in Europe and in the US, with, at the moment at least, what is reported 167 million TikTok videos that are viewed every minute, which of course leads to a tremendous amount of data that is at the moment transferred from from Europe to the US or to China, where it can then can be further used and further utilized and further also transferred and transformed into new solutions using AI without any limitations. And on top of this, it's obviously not only TikTok, it's also something like Google Lens, having reports about 8 billion Google Lens use cases every day. Of course, everyone using major Google services such as Google Photos, this is my personal photo history on Google, is fully searchable for AI developments, and is also already, of course, usable for me, but in principle also for everyone else using semantic search. So I can easily search there for stairs, or can easily search there for the environment, the venue, the place where the conference took place, which is the main building of Juridicum, where you can find, just in my own Google history, pictures leading back to 2014, so almost 10 years of history of me taking pictures at Schottenbastei. Of course, again, searchable, usable, and exploitable. And the argument that I tried to make here was, so this does not democratize. This is a very important competitive advantage that we have been further developing in Europe now, as we have become very heavy users of many of those solutions, in particular, but not limited to, ChatGPT, because the most recent version of this circle indicating what's happening in a minute on the internet has two interesting new developments here. Now, on the one hand, you find Office software such as Slack or Microsoft Teams there, meaning that there's plenty of also business-related information, of course, now that is exploitable, and also ChatGPT, all of us all the time writing prompts that can be exploited and used. So democratization is probably not the right term that I would use for this phenomenon. And I was then asking the question how we came to this, and what does it have to do with the audience, which, as I said, is young academics. And I also insisted that if Europe wants to be competitive here, and if Europe wants to achieve some kind of leadership here, it's not sufficient to come up to speed that is already there in the market, but that you need to run faster if you want to overtake people or countries or legislations or industries. So just being as fast as the others will not suffice. So how did we come there, and what does that have to do with the law? And the answer there was first, a lot of what you understand or what you see here today can be understood only if you go really back to the very beginning. So somewhere when computers looked like this to 1968 or so, when everyone who was in this room then had personal memories, in particular of World War II and the Nazi regime and the Holocaust and all the pervert developments that societies have taken somewhere in the first half of the 20th century. So my message here was, obviously, when these machines came, there were quite some people being rather concerned about this due to all the personal memories and personal experiences they have made during and before, during, and after the World War. And that might be one of the reasons why already then in 1968 ongoing, there were two main issues popping up in literature that dealt with this new phenomenon. And those two fields were, on the one hand, the potential, the options, the opportunities coming with those systems, because already then the argument was the legal system is in a crisis. There is too much information. We need to get rid of the information overflow, and we need to work with machines for that purpose. That was the one pillar of the argument, and the other one was we need to do some damage control and risk control here. We need to be careful that these systems can't be misused, and leading again into societies which are not democratic and which breach fundamental rights. And the outcome of this was that already from the 60s and 70s onwards, quite some laws were produced, in particular laws on data protection, such as the first law on data protection from the German region Hessen, which was published in 1970, and that knows already quite some of the fundamental principles of modern data protection law. In particular, this fundamental right, or this right to data protection, not yet a fundamental right then, but already a legally enforceable right to data protection, and also the idea, for example, that there should be someone, a Datenschutzbeauftragter, which is a data protection officer or a data protection authority in some cases, taking care of the enforcement of the law in the name and in replacement and in support of the data subject. So quite some of the tendencies that you know already from today were already started then. And since then, quite some time has passed, leading to developments such as the declaration, the digital agenda of Ursula von der Leyen when she came into power in 2019, presenting her agenda for Europe, which was the very first political paper written by her in this new upcoming role, where you then can find statements like this one here, that it may be too late to replicate hyperscalers, but it is not too late to achieve technological sovereignty in some critical technology areas, so that importantly, Europe is no longer really chasing for global leadership here, but mainly trying to at least guarantee some kind of minimal sovereignty in domains that are not run by European companies. And the instrument that von der Leyen then was announcing here was, in particular, that in her first 100 days of office, she would try to forward legislation for a coordinated approach on the human and ethical implications of artificial intelligence. So typically, Europe is in a way not really and no longer in the lead of the development, and has not been already in 1968, has not been in the lead of the development of these machines, at least when it comes to market competitiveness. Not necessarily when it comes to fundamental research, because Europe has been and still is probably quite in the lead in some of the areas there, but not when it comes to market readiness. So no longer this is the perspective, no longer this is the goal. It's mainly to be the first in regulating this domain. And then my hypothesis was that in my personal life there were 5 what I call iPhone moments. Again, coming back to this statement from before, so 5 life-changing, society-changing events that were computer-related. That was first the birth of the computer in 1968. Then it was the PC somewhere in the 80s. Then it was the internet, the web in the 90s. It was the moment when the iPhone was invented, and with the iPhone, all these social Web 2.0 applications entered the market. And then last not least, the ChatGPT event or moment that I was describing at the beginning. And my assumption here was now that in line with those 5 steps or 5 events, 3 academic generations in law tried to deal with those moments and tried to deal with those life-changing events. Each of those generations being in power for roughly about 25 years. The first generation, somewhere starting in the 70s. The second generation, somewhere starting in the 90s, and the third generation, somewhere starting now in the 20s of the 21st century. So my perspective here was when it comes to digital law, we have now 3 generations that were relevant here. The first one are those who are before my own generation, so the antecessors, and then it's my generation, and then it's the generation of the audience, so those who are now in their early 30s, perhaps late 20s, early 30s. And I started again with the antecessors, so the generation before my own one, the generation dealing with this phenomenon first, and I made a little bit of an overview about how this academic scene then, in my reading at least, looked like, with a very few amount of legal centers dealing with this, and scholars who dealt mainly with 2 aspects. As I mentioned already, the first one is this informational crisis aspect, the legal informatics, the computer science related aspect on the one hand, and the legal aspect on the other hand, which was mainly risk reduction driven, which was mainly therefore data protection driven. And my statement here was that this generation of legal scholars understood themselves mainly as dealing with both sides. So, on the one hand, being in charge of information systems, and therefore some kind of a computer science background was to be achieved, and on the other hand, something like a data protection, data risk controllership statement or position was to be achieved on the other hand. And this generation, I argued, had to go through 2 fundamentally challenging situations then during their academic lifetime. The first one was the birth of the PC in the 80s, and the second one was the one that was connected with this sound here that you hear now in the background. The audience, by the way, didn't hear it because, as usual, the sound didn't work properly in the hall. So what you hear now here So what you heard now here is what you needed to hear when you tried to be connected to the internet somewhere in the 90s. So those 2 moments in my argument were the 2 iPhone moments of this generation that was growing up somewhere with the large computers in the 60s. then suddenly being confronted with the PC and the internet, and with the internet, then with this fundamental claim, for example, described by John Perry Barlow brilliantly in this Declaration of the Independence of Cyberspace, indicating that law, which is normally connected with a territory that someone has under control, does not necessarily work in an environment where the information can be everywhere. So this declaration stating, you governments of the industrial world, you have no sovereignty where we gather, because your legal concepts of property, expression, identity, movement, and context do not apply to us. They are all based on matter, and there is no matter there. That was the second challenge that this generation needed to handle. And my argument was that the generation failed in handling those two challenges. First, academically, because they did not really succeed in establishing an independent academic subject in law schools, and they did not succeed in installing an independent subject in computer science schools either. The few chairs that were working in the domain, in most cases, did not have a formal qualification in computer science, which is not that astonishing, because computer science was not really invented as an academic subject either. But more importantly, perhaps also, many of them then in the academic day-to-day life were reduced in the legal informatics part of their education duties during legal education into something which I would call some kind of, database prompt writing skills. It's important to remind this prompt writing word here, because it was mainly about how to get better results out of URIS or BEC or other databases that were not really very user friendly then. This generation did not succeed in implementing any changes, any major changes in the legal curriculum, and they also did not really intensely have too much of a regulatory impact, a policy-making impact on regulatory approaches, as they were then chosen by the legislations in many legislations, including in particular also the European Union, then somewhere from the 90s onwards. And some complications appeared then in the 90s for this generation, on top of all the things that I said already, in particular the internet and the internet explosion, with all the complications also from a technical point of view, which made it very challenging then for this generation to make an argument about what exactly the domain was about, and what exactly they should deal with. And regulatory failures, and there were plenty of regulatory failures then, in particular in the 90s. And by failure, I mean legal acts that did not achieve the goal they were produced for. These regulatory failures, such as the Electronic Signatures Directive, or the E-commerce Directive, or the Data Protection Directive, etc., somewhere in the 90s, were not systematically reflected in academia. And then, during this internet burst in the 90s, something like my own generation entered the scene. So many of those first generation academics then left the professional market, and people in my age took over. And this generation, so my generation, then first thing to do was that the amount of centers was still relatively small. That was one of the issues we were facing quite quickly, and that also the term, or the subject, the discipline we were working for was unclear. So even the definition, whether this should be called cyber law or internet law or legal informatics or information law or whatsoever, or the law of the horse, so that it would make any sense at all that this field would exist, was one of the challenges already from the very beginning. Many of the people in my generation, because of the problems that the first generation had, didn't have a formal qualification in computer science either. The computer science related part of what we did was that we had some kind of a claim stating that we understand the internet and the social phenomenon coming with the internet, and then also some of the legal questions coming with the internet better than just traditional lawyers from the domain. So we take care of all these funny and loud and noisy and disturbing things, because we are geeky enough to be able to connect a computer to the internet or a printer to the computer, etc. Was the remaining claim of competence when it comes to computer science related parts of our work. And in the regulatory challenges and changes, I think the main claim that people in my generation who tried to focus in the domain was to say, listen, we understand Brussels with all these waves of legislation coming a little bit better than you, and we do this in a way that is internet friendly, so that we can try to merge, for example, copyright related points of view with data protection related points of view. And I then made the argument that also my generation went and is going through two iPhone moments. The first one is the iPhone and social media coming with the iPhone and all the apps. And the second one is the one we are going through right now in the moment. So this AI bubble that is bursting at the moment, despite of the fact that obviously a lot of the things that you see here are 50 years or more old, so that it's not really a bubble that is exploding here, but it's just the top of the iceberg that you see here. And I then argued also my generation is going through the whole failure cycle, just like the generation before, which means that we have still not really succeeded in establishing this properly in law schools or in schools of engineering. We still don't have any formal qualification. Many of us still don't have, including me, by the way, so I'm also talking about myself here. Many of us have no formal qualification in computer science. Many of us are requested to do something useful in their life by teaching real law, public law or private law or criminal law on top of everything. We are confronted with some kind of very bizarre understanding of what we should or should not teach when it comes to legal tech, or and are very challenged here by the very fact that it's quite difficult to talk about databases if you have never studied this systematically, and it's very difficult to talk about artificial intelligence if you've never, I mean, from a technical point of view, if you've never studied this systematically. And in particular, there haven't been, or there have almost not been, any changes whatsoever in the legal curriculum. The legal curriculum very much looks like it looked like 30 or 50 years ago. And again, quite some complications coming also from a technological point of view. We see this explosion of the internet, now the explosion of AI. We see very little interdisciplinary exchange in the average law school. And we again see plenty of legislation coming, a lot of legislation coming. And again, the regulatory failures coming with this legislation are not properly reflected, are not systematically reflected within academia. This wave now is no longer the directive wave that we saw in the 90s. It's now more about regulations. And many of those regulations, of course, will be covered and have to be covered by the conference. Many of them bringing a lot of additional red tape, many of them making things more complicated here in Europe, making things more complicated, despite of the fact that, in my view, many of those miss some of the most relevant points of what we should be concerned about in Europe. At the moment, one of them, again, would be the lack of competitiveness. So this is an issue, in my view, that is of most urgent importance. We are losing, we have been losing, and we no longer even try to be competitive in an environment where data is going lost and is transferred outside Europe everywhere in a tremendous speed, and with reactions from the legal system, which are looking very much like they looked already in the 90s, which is that sometime after the explosion took place, regulators such as the authorities, in this case the data protection authorities, appear. They identify all kinds of, in this case, data protection related issues, and it will most probably end in the very same picture as it ended when it comes to GDPR. One example here, the Irish Data Protection Authority just recently came to the final decision of fining Meta in a very famous case that took many, many years, fining Meta now for breaches of European data protection rules, fining Meta with the unbelievable amount of 1.2 billion euro fine for this breach, which then at the end, however, was perceived by the market in a very interesting way. This is a chart of the share price of Meta in the relevant period when this fine was published, and this is the peak that you could see when it became public that 1.2 billion euro would be the fine to pay. So this is, in my view, some kind of a symbol that this regulatory approach using traditional hard law instruments such as fining a company no longer really work, and in particular do not really work in Europe. And I then, from this point, also want to stress that not only when it comes to enforcement, which is this John Perry Barlow issue that I mentioned before, but also when it comes to legislation, so setting the rules, setting the field of play, we also miss the relevant points, the big relevant points in Europe, one of them being nuclear power and AI. So in how far nuclear weapons could be developed or are already developed, which are able to decide on its use independently using artificial intelligence, and research is undertaken here both in the US and in China. Quite significant amount of research is undertaken there in both regions, having quite some reason for conflict, as you know, and then perhaps being therefore an interesting target for European, not only, but also European attempts to regulate this. And one might expect perhaps that the AI regulation, which is, as Europe is very proud about to say, the very first attempt to regulate AI systematically, this attempt doesn't have anything on nuclear weapons in it. It does not even have anything on AI that is used for purely military purposes. And one could, of course, now argue, and this is a very valid argument, that, of course, in the AI Act, there can't be anything on military usage there and military purposes for competency reasons and strategic reasons and so on, which is not my point here. My point here is we as Europe and as European legislators are failing here, or are missing one of the most fundamental challenges at the moment, because I'm not aware of any really feasible attempt to regulate the usage of AI for military purposes. But also, second part of the argument, within the scope of the AI regulation draft, we are missing the point in this beautiful thesis written by a young academic in German. It is quite clearly described how the existing IT environment in Germany and presumably in other areas of the world are undermined, I would say, are undermined by the usage of AI already now, without any systematically working control infrastructure. So already now, this is, of course, an issue, so that the regulation, in my view, is also missing in quite significant parts by being rather late, this already existing threats. And then third part of the argument, what is also quite significantly missed in this is that all the relevant parts of such a piece of legislation, so for example, the scope, So what exactly should be AI and what should not be AI, or the scope in the sense of what is regulated by the regulation and what is regulated by GDPR and other pieces of legislation, or how should all these authorities cooperate with each other. And finally, last not least, very much in the core of this whole piece, what is a high risk AI application and for what reason should this be regulated more intensely than others? In all those sub questions, one could answer very easily, very legally, with a 200 pages paper on this, which does, however, increase complexity for companies, for industry, for stakeholders, for NGOs, for everyone in Europe dealing with this and trying to make Europe more competitive or make Europe, in a way, a global factor again in the domain. So every single one of those questions can't be simply answered at the moment. Everything here is under debate, which is very good for lawyers because they make a living out of this, but very bad for European stakeholders and European industry and citizens. For example, one of the pain points here that one could highlight is that there are definitions on what a high risk AI system might be, but some of those definitions lead into a situation where one could, for example, argue that the development of competitive legal tech solutions in Europe will be significantly delayed because a high risk system can, for example, be, according to the Annex 3 of the regulation as it is proposed by the Commission, such a high risk system, which means that there is lots of regulatory requirements coming with the implementation of such a system and the development of such a system. Such a high risk system may inter alia be an AI system that is intended to assist the judicial authority in researching and interpreting facts and the law, and in applying the law to a concrete set of facts. So something which helps you, it's not that it replaces you, it's about helping, assisting a lawyer or a judicial authority to do research on the regulatory environment of the case, on the law. That might already be a high risk system, and if this were true, then I would expect that the already now not really highly competitive legal tech scene in Europe, which inter alia is at the moment held behind by the very fact that we have less data available than other areas of the world when it comes to the development of such technologies. This leads back to the beginning of this presentation, will be further delayed and will further lose in this globally competitive markets. Which led me then in the last part of the presentation to the generation I was talking to. So the young people that are part of the Young Digital Law Initiative. And I stated that I don't know yet, and probably they don't know either, what would be their two iPhone moments. So their two generation changing moments of internet or digital developments that would take place. But I would presume that all the failures and challenges that the two generations before theirs would be repeated and are at the moment very urgently on the table. One of them being that still the field is not really fully established in law schools. Still, it's not fully established in computer science schools either. The curriculum has not really changed. The role of academics in the domain is rather unclear because many of my generation have become some kind of cheap consultants or for free consultants for the policy making process without asking the really fundamental questions about in how far the legal system as a whole can be a tool of regulating the developments properly. And this on top of all the complications also coming with these misdevelopments, the most important one perhaps, that it is very unclear at the moment, at least in my perception, how to build an academic career as a junior researcher at the moment in this domain under these circumstances, which are highly unclear, both from a technological point of view and from a legal point of view. That is highly unclear and unpredictable in how far it will be possible for that generation to finally change the legal curriculum in a way that makes it more attractive for their own academic career making. Also unclear how we could better steer what's going on in the lawmaking process, because my generation, as I said before, clearly failed in asking the fundamental questions whether this is working at all. And as my generation failed in this, we have a lawmaker on steroids working, in particular in Brussels at the moment, regulating constantly things unbelievably intensely in a way that keeps us lawyers very, very busy, but produces unbelievable legal complexities for everyone who is out there in the industry. And with a lot of uncertainty, therefore, then also on the questions in how far lawyers have to and should be informed and should have a say on what's happening outside the law. So how to organize the interplay, in particular with computer science, but also with social sciences and the humanities. So interdisciplinarity as an unsolved issue here, because careers are still built on monodisciplinary excellence. And on the other hand, it is, of course, an urgent requirement here to have a proper understanding about what's really going on in the world. And then the last and very final question, which is, how can we as a legal system, how can the legal system as a whole remain relevant for society as a problem-solving institution? My very last provocation here was, law has not done very well in the last 50 years in fulfilling its main role, which is being the right forum for the solution of conflicts. People tend to evade and tend to escape from the legal system in different ways, and by technological means, by economical means, by social means, not really leading to situations where the law is no longer in the central position it was perhaps 50 years ago. So we also lose a lot of relevance as lawyers and as a legal system. So this is another fundamental challenge for this generation. So I ended there somewhere with an advertisement that a lot of what I was developing there as an argument is further developed in Ars Boni. In particular, also with the most recent edition of Ars Boni, where I had the privilege to talk with Barbara Peinsack on democracy in the digital age, covering quite some of the points that I tried to make here also in this presentation. And I then ended with the invitation to ask questions, and there were some questions also about academic career making, in particular coming from younger colleagues there. And I would like to end this presentation here by two things. The first one is, if you still want to go through this process of an academic career, we have always positions, or almost always positions, available in Vienna, and we would very much like to hear from you. At the moment, we have positions open, and there is a deadline approaching somewhere in a week or so, so mid of July, but also afterwards we will have positions. So if you think, if you like what we are doing here, then kindly let us hear from you. And the second point that I made there and that I want to make here again is, of course, there are plenty of challenges for this generation, for your generation, your younger generation, but it's probably still the most interesting area of the law I ever met, and it's the most beautiful career that one can make, to go to academia. So do it. We need you there. Thank you. Enjoy the day or the afternoon of whatever time it is in your area. All the best. Bye-bye.